Brian Cole Jr., the man suspected, accused, arrested, charged with planting the January 6 pipe bombs. A 30-year-old, apparently autistic, borderline semi-verbal, unclear, a man who has escaped, evaded law enforcement for the last 5 years, a mastermind who started buying the pipe bomb components a year and a half to 2 years before he even planted the pipe bombs, has been arrested. He was arrested about a month and a half after Steve Baker from Blaze put out an expose, a bombshell expose, identifying who Steve Baker thought was responsible for planting the pipe bombs. And the person that Steve Baker thought was responsible, who he detailed in his expose, happens to be a Capitol Police officer, and happens to be a Capitol Police officer that was, in fact, on the Capitol premises on January 6th, firing rubber bullets and tear gas into the crowd in a not less than lethal manner, in a potentially lethal manner. So, although her attorney has denied that she has any involvement in planting the pipe bomb, admitted to everybody, even to Julie Kelly, who admitted that this Capitol Police officer violated civil rights by firing on the crowd in the manner that she did. She was identified by Steve Baker as being the potential pipe bomber. A month after that, the FBI, the DOJ announces the arrest. They finally found the man, Brian Cole Jr., a man who was 25 years old, according to all of his neighbors, dysfunctionally autistic, did nothing but walk his chihuahua with his headphones on, barely said 2 words to anybody. A mastermind, who purchased these pipe bombs material over years before the event, then got so apparently angry with the results of the 2020 elections, he decided to build the pipe bombs, plant the pipe bombs, and he somehow evaded arrest for over 5 years. He's been arrested. He's been detained since his arrest. And the government has made a motion requesting detention of Brian Cole Jr. pending his trial, until his trial. Eighth Amendment of the Constitution, unreasonable bail be damned. They want to detain this man until his trial. Because as they say, and as we'll see when we go through that proceeding, he poses such a risk to the community that detention until his trial is the only way of ensuring that this man, who has been on the lam for 5 years, never had a criminal record before, never had a run-in since, didn't try to flee, didn't carry out any violence, didn't resist arrest, never had any issue. He's such a menace to society that they need to lock him up, detain him until his trial. But before we even get into that, because the most amazing thing is another motion that they filed, which is the motion to confirm the preliminary hearing date, defendant Brian Cole Jr.'s motion to confirm preliminary hearing date, because it would seem this man's been detained since he was arrested, and it would seem that the government might not be ready or might be trying to push back his preliminary hearing date. Were they debate probable cause? It's a short document. We're going to walk through it. United States District Court for the District of Columbia. Defendant Brian Cole's motion to confirm preliminary hearing date. Defendant Brian Cole Jr., through the undersigned counsel, respectfully moves the court to 1, confirm the hearing date already set for the 30th, which is tomorrow. I'll be following this. That it will proceed in accordance with Rule 5.1, which is, to have your hearing date within 14 days of arrest, whatever. But they've consented to a bit of an extension because of the volume of documentation the DOJ dumped on Brian Cole. Parties previously set December 30th as the date for the detention hearing. Defense did not waive the right to a preliminary hearing. To the contrary, consistently expected to proceed on December 30th. On December 28th, 2025, when pressed on the question of proceeding with the preliminary hearing on December 30th, the government asked to push the preliminary hearing to January 7 or 8. This is the man who's already been detained, Brian Cole. A man who's been separated from his headphones and his video games, who is, by all accounts that anybody knows, autistic. The only question is the degree to which he's autistic and his level of functionality. Now, what's another week in detention? This is how the system works, by the way. It's not just, when they arrested Trump and we saw how the federal prosecution system can be weaponized, and everyone's like, they've been doing this forever to everybody. It's just now because they're doing it to Trump that it's being exposed and people are outraged at the levels of abuse. Now we're witnessing this with Brian Cole Jr. He's been in jail, detained since his arrest, And now they just, let's push it back another week. The request comes too late, does not meet Rule 5.1's vigorous standards. The court should confirm the hearing date. Federal rule, we get into it. The rule is that you have to have your date within a certain time frame, and they agreed to a consent postponement to December 30th, and apparently the government wants to push it back a little more. Why? Who knows? In its email to Defense Counsel, the government has identified no extraordinary circumstances. Rather, the reasons referenced are ordinary scheduling matters and the possibility of a forthcoming indictment. Rule 5 does not allow the preliminary hearing date to be extended merely to accommodate the pace of the grand jury investigation. So there might be an indictment because they didn't proceed by way of indictment. Remember that, salient detail. Statutory framework is equally clear. Section 30, okay, whatever. So you have to have it within a certain time frame. Courts enforce that mandate, yada, yada, yada. To be clear, Mr. Cole, through counsel, consented to an extension until Tuesday, December 30th, but he has not consented to any further delay. As a result, December 30th is the proper, timely date for the preliminary hearing under Rule 5.1. The government's desire to accommodate ordinary scheduling or the pace of a grand jury is not a lawful basis to continue the hearing for which it has had more than 3 weeks to prepare. When we talked about the indictment against James Comey, slop, garbage in, garbage out, last minute rushed indictment that has now been tossed, and last I checked, it hasn't been refiled. It looks like we got another case of this here. Just slop, rushed work, and now they expect the guy, Brian Cole, to be detained so they can continue their grand jury investigations and try to get an indictment. The court should therefore confirm that December 30th will proceed as the Rule 5.1 preliminary hearing and enter an order that the government must be prepared to present evidence establishing probable cause and for reasons of efficiency and fairness that the detention hearing be heard the same day. There's a chance that they don't even have sufficient probable cause in this case. Understand that as well. Hold on a second. Stop playing piano! Give me one sec. Stop playing piano! Thank you. All right, now where was I? Because I was distracted by the wonderful music. Were we here? The government already has indicated it will seek detention and invoke a rebuttal presumption. Coordinating the detention determination with the preliminary probable cause determination avoids serial litigation, conserves judicial resources, and protects Mr. Cole's statutory rights, consistent with Rule 5.1d. Court should further make clear that no continuance beyond December 30th will be granted. If the preliminary hearing is not held within the period fixed in compliance with Rule 5.1 and absent yada, yada, yada. Conclusions. Defendant Cole respectfully moves the court to grant the motion in full, confirm December 30th date will proceed, direct the government to be prepared to present evidence, and to deny any further continuance absent the strict rule, yada, yada, yada. They're going to present their evidence. We're going to see whether or not there's actually sufficient probable cause for this arrest. We've gone through the indictment. Mike Benz said it was a strong indictment. I said, when Mike Benz says that, that's a strong endorsement. But we have since had a number of other investigative exposés delving into that. It wasn't an indictment. It was the affidavit for arrest. It might not be as strong as everyone thought it was. That's the motion to not postpone the preliminary hearing scheduled for tomorrow. Dude, I'll be following it. We're going live at 3:00. It's going to be a sidebar-ish, but I'll be following that and doing updates on that. The government filed a motion as well. And if you haven't seen this motion, which I don't think you have, you're going to have to see this. First of all, it's here we go, respectfully submitted. This is the attorney. Wait, is this the one here? No, this is the... Now I'm pulling up so I got the memorandum for pretrial detention. Is not the right document. No, that is the right document. Okay, good. Memorandum for pretrial detention is the government saying, we want to hold Brian Cole until his trial. And what they've said in this motion is actually kind of amazing, kind of stunning. Remember, when we went through the affidavit, and I'm like, oh, they've alleged that he bought the pipes, the caps, the cables, the steel wool, and that he just put together the black powder. And I'm like, when did he buy the black powder? When did he buy the materials for the black powder? They've got him buying everything under the sun, except, the ingredients that go into making black powder: sulfur, potassium nitrate, saltpeter. I said, why don't they have evidence of when he bought the actual ingredients for the black powder? Listen to this. United States, by and through its attorney, United States Attorney for the District of Columbia, respectfully submits this memorandum in support of its oral motion for defendant Cole to be detained pending trial. That means locked up until they have his trial, whenever that is. And we've seen what happens to people in federal detention. Defendant is charged by complaint with transporting 2 explosives, IEDs. Government seeks pretrial detention under Rule 18 USC, whatever it is here. Section 844 is listed as a federal crime of terrorism, yada, yada, yada. Upon finding of probable cause that the defendant violated Section 844I, the federal bail statute creates a rebuttable presumption that no conditions will reasonably assure the community's safety if the defendant is released pending trial. The defendant cannot rebut this presumption, considering the extreme and profoundly serious nature of his crimes, the overwhelming evidence of his guilt, the years he has spent deceiving those around him to avoid accountability, and listen to this is the part that's just like the kicker, and the intolerable risk that he will again resort to violence to express his frustration with the world around him. Who the hell wrote this? The court should detain in pending trial. Who the heck wrote this? What reads like a high school drama. He will resort to violence to express his frustrations with the world around him. He will again resort to violence. By all the allegations out there, he's only resorted to violence. I say only. In the allegations of having allegedly planted those pipe bombs based on the, what I now consider to be maybe less than strong evidence in their affidavit. He's been on the lam. He's been on the run for 5 years. What has he done? Walk his dog twice daily? It's crazy. December 4th, he was arrested. January 5th, charges against the defendant. Yada, yada, yada. We know that. This is what the evidence is. This is largely a reiteration of the evidence in the affidavit. They talk about how he was driving. His 27, this is the night of the bombs being planted. 24 minutes later, 7:34, surveillance video first captured the defendant walking approximately 1/2 mile from the South Capitol Street to the intersection. That's captured in the video, and shown below, the defendant was holding a backpack. All right. So they say he allegedly planted the bombs. We know this. The footage also showed the defendant, who investigators from the FBI, based on height analysis of video, estimated 5'7", with a margin of error of 1.1 inches, putting on a pair of glasses. Defendant is approximately 5'6" and wears corrective eyeglasses. 7:39, 5 minutes later, he's captured on surveillance video. We know all of this. They got him allegedly based on the pings. The pings have their own problems, considering 2 of the pings are within the outermost limits of what the cell towers are able to capture by way of ping of the cell phone. So we go over that. We've already done that. We have the pipe bombs. About 20 minutes later, 8:15, the defendant's cell phone interacted with the cell tower, consistent with him being in the area of Rumsey Court, southeast. In the area can mean a lot of things. Surveillance video showed at approximately 8:14, defendant exited Rumsey Court and walked westbound. By the way, what the video showed is the hoodie person, which we're being told to believe is Brian Cole Jr., a man who has disproportionately short legs, a man who everybody who knows him says is not him walking in the video. So that's what they're telling. Okay, fine. We know all of this stuff. They talk about this, the pinging, and we've gone over the pinging, where these are the towers. This is what they can measure. And a couple of the pings were very much on the outer limits of the reach of these cell towers, which I think are 120 degrees. Pipe bombs. Here's this. Pipe bombs that the defendant planted near the RNC did not detonate. Okay, fine. We want to get into the interrogation. Both pipe bombs were manufactured using a collection of components and a main explosive charge. I'm not... They're really showing you some detail here. The FBI obtained records showing his credit cards. He bought some of the parts January 18 to 2021. Yada, yada, yada. Between 2018 and 2020, defendant purchased numerous components. 2018, January 6 or January 5, 2021. Years before, they got him buying these components. By the way, remember the question that I did ask is, he bought a timer. Did he buy the timer that was used on these pipe bombs? That's, I would imagine, is pretty easy to determine. If he bought 2 timers, fine. Were they the very same model? Maybe not the serialized number. I don't know. Maybe you don't have that. Did he buy the same model? That is easy enough to determine. And we don't have an answer to that question. He bought safety glasses, wire stripping, all this stuff. Okay, fine. So we got that part. Defendant's arrest and confession. Listen to this. And operate on the basis that, we don't have evidence to the contrary. This is an autistic 30-year-old. You want to talk about false confessions that you get from cognitively fully functional adults like Michael Flynn, who gave a false guilty plea to spare the prosecution of his son. Michael Flynn, who is not autistic. You wonder what they can get away with people who are mentally vulnerable. December 4, 2025, law enforcement executed an arrest warrant for the defendant, took him into custody. Search warrants were executed on the defendant's person, his home, etc., and his car. By the way, remember also, apparently they haven't taken his Nissan Sentra in as evidence. They have not seized his vehicle as evidence. Samsung cellular device was seized from the defendant's person at the time of his arrest. A forensic review of the device's contents showed that between December 2020 and December 2025, the device recorded 943 events identified as factory reset or wipe, including approximately 3 hours before the defendant's arrest on December 2025. Choking on my own tongue here. My question is, I didn't know that you could actually verify how many times a phone has been factory reset. What I find interesting here is they say they've identified 943 events identified as a factory reset. They don't say factory resets. So the question I'm asking is, might it have been another time? I don't even know what sense to make of this, but apparently he is compulsively wiping his phone, compulsively factory resetting his phone. Guess we won't be seeing any videos of him playing with his puppies at the time the pipe bombs were placed. Bada bing, bada boom. Remember, that was the alleged alibi of the person Steve Baker identified in his expose, playing with her puppies at the time the pipe bombs were placed, except the individual that Steve Baker identified did not have puppies, plural, but only had one dog that was an adult at the time the pipe bombs were placed, or at least a mature dog. Inside defendant's home, law enforcement recovered, among other evidence, a Home Depot shopping bag containing 3 black iron caps, galvanized cap, yada, 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 and a Home Depot receipt dated November 16, 2020. As I read this, I keep having more questions. He had a receipt from 5 years ago when they arrested him. Inside the defendant's home, they recovered evidence when they arrested him on December 4th, a Home Depot receipt from 2020. He wiped his phone 943 times, presumably to evade arrest or to conceal his wrongdoing, but held on to a receipt from 5 years earlier. Okay. And we got some other... Okay, fine. Following his arrest, defendant was transported from Woodbridge, Virginia, to the FBI's office. He was interviewed. During the interview, which was video recorded, the defendant initially denied manufacturing, transporting, planting the pipe bombs. When asked about his whereabouts, on January 5th, defendant stated he drove his Nissan to Washington by himself that evening to attend a protest concerning the outcome of the 2020 election. Defendant explained, I didn't agree with what happened, yada, yada, yada. He's never really been openly political, does not discuss politics to avoid conflict. He doesn't discuss politics often with family to avoid conflict, and yet decides to blow something up because of his political orientations. Okay. According to defendant, no one knows his political views, including his family. Defendant stated that he did not align politically with his family members and did not tell them that he was going to protest in support of President Trump. Later in the interview, by the way, he waived his Miranda rights, so this is without counsel. Let me just make sure that I got that part right. Here we go. He executed a written waiver of his Miranda rights. If this kid is in fact autistic, how does an autistic individual who might not be able to consent to certain contracts consent to waiving his Miranda rights? Okay. Speaking without an attorney. Later in the interview, defendant explained that after the 2020 election, something was wrong. He began following the issues closely on YouTube, Reddit, felt bewildered. Okay, fine. As the interview continued, defendant maintained that he did not plant the bombs. However, when the defendant was shown a picture of the Nike Air Max Speed turf shoe, he admitted that he used to have a pair. Like that, or the pair, and that he threw them away because they were old and they were coming apart. Did he buy them? Do you have the receipt of him buying the shoes? You got a receipt of him buying the the wires, goggles. Do you have a receipt of him buying the shoes? Did he get them at a thrift shop? Cash? Did he order them online? Does he have proof of purchase of these shoes? Okay, fine. He says he used to have a pair. He threw them out. Approximately 2 hours, during which the defendant maintained that he had not planted the bombs, one of the interviewing agents asked if he wanted to end the interview. Defendant responded that everything is just blank and a little too much to process. So they kept going. They then suggested that the defendant look at a video footage from the night of January 5th, when defendant was shown a still image of himself on surveillance. The interviewing agents reminded the defendant that, here we go. When the defendant was shown a still image of himself on surveillance, he stated he did not recognize the person and had not previously seen the video. The interview agents reminded him that lying to them was an additional criminal offense. Oh, let's intimidate the autistic kid Say if he lies, if you don't admit to this, you're going to go to jail for lying. This time he paused for about 15 seconds, placed his head face down on the table, and answered yes. After the defendant's admission, the interviewing agents explained to him that they could either continue to discuss his actions on January 5, or they could stop the interview and transport the defendant to the court for his initial appearance. They explained his yada yada. Okay, fine. Over the next approximately 1.5 hours, the defendant walked the interview's agents through his construction, transportation, planting of the pipe bombs. Defendant explained that he made the black powder in the devices using charcoal, Lily Miller sulfur dust, and potassium nitrate that he purchased from Lowe's. Do we have the purchase receipts for this? If they did, I mean, it would be damning. They got the purchase from Home Depot for the pipes, for the wire. Do they have it for the potassium nitrate? Defendant mixed those ingredients in Pyrex bowls, yada, yada, yada. Regarding the construction of the devices, defendant explained that he used a hand drill. Okay, fine, whatever. Defendant stated that he transported the devices to Washington, D.C. inside a shoebox. He wore a mask and a hood that evening to avoid identification. He wore gloves to avoid leaving fingerprints. According to the defendant, he was not really thinking about how people would react if the bombs went off. He said they were grateful that they didn't. Argument. Then they go into why he has to be detained. Just appreciate, by the way, one other footnote here. The first factory reset or wipe event took place on December 15, 2020. Is that not even before? January 5th, 2021. So he wiped the phone before he planted the bombs. The next such event did not occur until July 15 of 2022, 2 years later. From that date, the factory reset or wipe events occurred at least once a week. On some days, the device appears to have been wiped multiple times in the same day. So he wiped the phone before planting the bombs and then just got into a wiping frenzy. Can't stop wiping. We don't need to go into the law. They just basically go through all the criteria. Poses an intolerable risk, danger to the community if released. Weigh the 4 factors: the nature of the circumstances of the offenses, the weight of the evidence against the defendant, his history, characteristics, the nature of the seriousness of the danger posed to the community that would be posed by his release. They fail, in my view, on all 4 of these. And so we go through them one by one, which I won't. Nature of the offenses, weight of the evidence against the defendant, overwhelming. Defendant's history. Although he has not had any prior contact with the criminal justice system, his personal history and circumstances demonstrate that conditions less restrictive than detention will not reasonably assure the community's safety while this case proceeds. Horse crap. Danger to the community. He confessed. Put simply, the defendant poses an uncommonly serious danger. So serious, when they went to arrest him, they didn't cordon off the block and evacuate his neighbors because of the risk of pipe bomb explosion. Respectfully request that the court grant this motion to detain the defendant pending trial. Okay. It's outrageous. And I don't know if I'm too biased, already foregone in my conclusions, that I don't believe that it's him. I would even concede that even if you believe it's him, pretrial detention is absolutely outrageous. Arguing those 4 conditions in favor of his pretrial detention is untenable, to put it mildly. And it's as though now the Constitution doesn't exist just because, people are willing to sacrifice the 8th Amendment because their political party's in power and they want to have this victory, have this W. They found the pipe bomber, an autistic 30-year-old kid with no criminal record, don't have the receipts for his shoes, don't have purchase receipts for the potassium nitrate, the sulfur, and the evidence that they have are pings in a cell tower that are on the limits of what would put him there in any event, and he might have been something of a DoorDash driver delivering food in any event.